Hello, everyone. Thank you for joining our today's webinar. My name is Alexander Melnik. I am head of corporate and M&A practice at GOLAW law firm. Today with me also my colleagues who will reveal their faces a little bit later. It's Victoria Bublichenko, who is the head of tax restructuring, claims and recoveries practice at GOLAW. Pavlo Loginov, who is partner and head of antitrust and competition practice at GOLAW, and Katerina Tsvetkova, who is the counsel and head of the employment law practice at GOLAW firm. Few words about our firm. GOLAW is a leading Ukrainian law firm operating in compliance with international and national standards. We have offices in Kyiv and Berlin, and our firm operates for more than 20 years, since 2003. It has been recognized by prestigious international rankings such as Legal 500, Chambers and Partners, IFLR 1000 Best Lawyers, Who is Who Legal, and so on. For the last 8 years, GOLAW is ranked among the top 10 leading law firms of Ukraine and currently holds the 4th place in the national ranking. The client portfolio of our firm includes large and medium-sized business, both foreign and national, including banks, financial institutions, private investors who are doing business in Ukraine or abroad. We would like to thank Ost-Ausschuss der Deutschen Wirtschaft for the opportunity to hold today's event and share our thoughts about doing business in Ukraine under martial law. Today we will discuss the opportunities and complications which business may face under martial law, as well as discuss some easements, changes, and limitations which apply to business. In case any questions arise during the webinar, please feel free to put them into the chat and we will answer them during Q&A session, which will take place in the end. So, okay, let's start. Undoubtedly and predictably, the war reduced business activities and have huge impact on it. For many businesses in Ukraine, the imposition of martial law led to increased uncertainty and disruption. Economic activity slowed down, and many businesses struggle to operate under new restrictions and regulations. Some businesses were forced to close temporarily, while others experienced a drop and decline in sales and revenue. In order to understand the change, we brought several numbers to the slide. So it shows the number of new registrations of business in Ukraine. As you can see, during 2020, by the end of 2020, at the beginning of 2021, despite COVID outbreak, almost 38 new business legal entities were incorporated in Ukraine. In 2021, this number rose to 41,500. During 2022, only 28,000 companies were created. Thus, as you can see, the war caused significant drop in business creation by almost 33%. However, at 2023, it starts to recover gradually. It was mentioning, however, that according to statistics, the number of business liquidations is minimal and keeps on the same level as it was before the war. So what complications and what are the main features of starting and running business in Ukraine during martial law? Obviously, the war has a negative impact on all spheres of life, including business activity. In particular, currently business faces numerous restrictions which are set on the legislation level. For example, the most crucial are export limitations. The Cabinet of Ministers of Ukraine has approved rules for export of a range of agricultural goods and products, export of which requires obtaining of special license. Such goods include, for example, domestic chicken, meat and eggs, cattle, frozen beef, salted, dried or smoked meat, sugar, oats, rye, fertilizers, coal and solid fuels made out of coal. Moreover, the government has banned export of certain goods. These include buckwheat, salt, liquid fuels, gas, natural gas with origin from Ukraine, wood fuel in form of pellets and branches, chips, and similar forms. In addition to this restriction, also a temporary moratorium has been imposed on vast majority of cross-border payments from Ukraine. Effectively, this blocks transfers from Ukraine abroad subject to certain exemptions, which we will discuss a little bit later. During martial law, it is also rules for mobilization and travel restriction was introduced for military obliged individuals. Therefore, business observes risks for staff to be mobilized to the army, and it also disrupts its activity. Also, as many people may know, the possibility of compulsory property alienation was introduced. However, it only sounds that rough and scary. However, it is important to note that in practice, compulsory property alienation during martial law is only authorized in exceptional cases and shall be carried out in line with strict legal procedure. The government must follow due process and ensure that the rights of the owner are respected. So in practice, business do not see that much risk in this limitation. And of course, what should be noted that any cooperation with or business activity with Russia or Russian citizens or Russian business can pose a serious threat to Ukrainian companies who tend to cooperate with them. The imposition of sanctions entails significant restriction for those against whom they are imposed. Sanctions comprise, for example, cancellation of permits and licenses, prohibition of foreign economic activity, prohibition of transportation and transit, freezing or blocking of assets, restriction on financial and economic operation, prohibition of entry, ban on registration actions, and so on. It is prohibited in Ukraine to execute agreement to which the Russian citizen or Russian Federation or Russian business is a party. So if you have agreement and the other side is Russian counterpart, you are not allowed to execute this agreement despite the fact that you may have debts or obligations. It should be understood that similar restrictions and prohibitions may extend to all companies that decide to cooperate with sanctions counterparts, including potential criminal liability, risks of property confiscations, and so on. So these are the major concerns for business which arise from martial law. However, along with these negative implications, there are also some positive outcomes. For instance, the moratorium for inspections of authorities was introduced from the beginning of martial law, and it continues. During the whole period of martial law, business was relieved from scheduled inspections. The planned date of cancellation of this moratorium is scheduled for 1st of July of 2023. However, at least this second quarter of the year, the moratorium will be in effect, and also we hope that the government may postpone this cancellation of moratorium to some other date. Another example is simplification of licensing procedures. So if before the war, certain types of activities required obtaining of licenses, which of course was a complicated procedure, currently most of these activities which required licenses before can be done by the companies by submitting one simple electronic documents which called Declaration for Provision of Business Activity. This declaration is submitted in two simple steps via service DIA, and the company can freely operate in respective business activities. So, for example, if you want to perform construction activity, you do not need to obtain the license. You shall just submit this special declaration. Also, there are numerous tax benefits for business were introduced, which we will discuss a little bit later, and including the launch of the DSCT regime for IT business, which provide a beneficial taxation and other flexible instruments for IT business. And Ukraine now is open as never before for investment. As was said during the presentation of the investment platform called Advantage Ukraine, the biggest financial risk nowadays is not investing in Ukraine right now. So let's talk a little bit about investments and what are the opportunities for foreign investors in Ukraine. President of Ukraine has presented an Advantage Ukraine, a platform for potential foreign investors. You can visit the website by the link which is you can see on the slide. More than 500 investment projects and opportunities in 10 branches of economy are gathered here. Ukraine can offer foreign investors a variety of sectors which can create high added value and whose products can be competitive in global markets. It includes, for example, energy. It has more than 177 billion potential in investment. Ukraine can generate dozens of electricity and green hydrogen facilities and has already begun cooperation with different countries and attracting funding. The EU's hydrogen strategy, which makes promoting the use of renewable hydrogen a top priority, has recognized Ukraine as a priority partner. And of course, everybody knows that energy infrastructure was being shelled by Russia, so it requires a lot of investments for renovation. Also, logistics and infrastructure. Ukraine's geographical location makes it an important transit corridor for trade. Logistics is one of the most important sectors that is currently in need for large investment due to outcome of the war. The list includes also the defense industry, agricultural sector, where foreign investor can invest in both production by leasing agricultural land or in processing agricultural products. Metallurgy and metal processing also requires huge investments because Ukraine, as in the result of war, Ukrainian steel industry has lost number of important facilities such as Alchevsk Iron and Steel Works, Yanikeyev Iron and Steel Works, Donetsk Stal, Kharkiv Pipe Plant, Azov Stal, and Mariupol Iron and Steel Works. Industrial production, natural resources, and of course, IT business. Ukraine is one of the first countries who introduced unified system of official and government documents in electronic form called DIA. And also Ukraine launched, as I mentioned, the DSCT regime, a favorable economic environment and legal framework within which IT business can transparently operate with very low tax burden. So, of course, it's obvious that foreign investors are concerned with war risks. That is why Ukraine is currently works on introduction of the mechanism for insurance of war risk and protection of investments. Ukrainian government holds negotiation with DFC and MIGA and currently considers several options for ensuring these risks. First is for creation a special trust fund and underwriting the partner within the structure of existing insurance agency, or change the management or create new agency for this purpose. So we expect the adoption of such mechanisms in the nearest future. So, meanwhile, despite the war risks, new business already comes to Ukraine, and we see this rise in demand among our clients. We propose in this regard to discuss how a foreign investor can invest in Ukrainian economy. So according to our law, foreign investments are defined as assets invested by foreign investors in the investment objects to make profit or achieve social effect. Such assets may include property rights, securities, targeted cash deposits, scientific and technological products, intellectual property, intangible assets, cash, and so on. Foreign investments can be made in various forms, which are not limited by the law. However, this includes, for example, that the investment can be made in form of partial participation in companies established jointly with Ukrainian legal entities, or by acquiring shares in such legal entities, by incorporation of new companies wholly owned by foreign investor, establishing branches and other separate subdivisions of foreign legal entities, and so on. Acquisition of immovable or movable property, including houses, apartments, premises, equipment, vehicles, land, and so on. Privatization of assets. Acquisitions of the right to use natural resources. Acquisition of the property rights, and in other forms which are not directly prohibited by the law. So, of course, one of the easiest way now is to create a new company, create business in Ukraine. In this regard, we want to draw attention that this option is not blocked, although public access to most number of register is now still closed. Almost all of the registration actions are available for both local and foreign investors, so you can easily set up a company. In fact, the major restrictions in regard to registration actions with business entities introduced only in relation to Russia and Russian citizens, Russian business, so they cannot start business in Ukraine. When you decide to start business, you have two major options. Foreign investor can conduct a business activity in Ukraine in two forms. First, it's creation of a separate legal entity, and the second form is representative office of foreign legal entity. These are two completely different forms of legal presence in Ukraine, which have different legal outcomes and possibilities. So just a simple comparison, if we speak about legal entity, it is a separate legal entity which operates independently, has its own bank account, assets, and so on, and its own legal personality, so it bears its own responsibility. If we speak about representative office, it is not a legal entity, it is a part, subdivision, or office or branch of foreign company, which is located in Ukraine and conduct activities under the name and management of its parent company. It is crucial to know that the representative office, in fact, performs only supportive activity, or its activity shall correspond to those which are run by parent company. Another difference is charter documents. The statute documents of legal entities usually charter, or it can be also called bylaws, and the law establishes special requirements to its content. Whereas for a representative office, the statute document is regulation, and it is not compulsory but recommended to have. Also, the process of incorporation differs greatly. Generally, incorporating of the legal entity is a very simple procedure, which may take up to 2 business days once you submitted all the documents to the state register. Whereas the registration of representative office of the foreign company may take minimum 20 business days for registration, which poses, of course, great risks, because in case of refusal, it may disrupt plans for conducting business in Ukraine. Also, taxation differs greatly. Taxation of legal entities is carried out under the rules of Ukrainian legislation. Representative offices can be taxed differently depending on their status. There are two main forms of representative office, commercial or non-commercial. So non-commercial usually is not taxed in Ukraine, and it conducts only limited supportive activity. The commercial representative office usually falls under the terms of permanent establishment and is subject to corporate taxes here in Ukraine. Another major difference is foreign staff legalization. For legal entities, in order to employ foreign national as employee, it is necessary to receive work permit for each employee. Only after this, such an employee will be able to enter Ukraine and work for the company. In its turn, for representative office, obtaining of work permit for foreign employees is not required, so it significantly simplifies the legalization of their stay in Ukraine. And the last major difference is management. The company usually managed by a director or board of directors, and their activity is regulated by the charter. In contrast, a representative office is governed by the head of the representative office, who acts on the basis of power of attorney, and respectively, all the major decisions are adopted by the mother company. So, of course, if you plan to conduct commercial activity in Ukraine, it is more suitable to incorporate the company, especially if this activity which you plan to do is subject to licensing, because in certain cases, it is impossible to obtain the license by representative office. For example, construction activity, due to special regulation, peculiarities of regulation, the representative office of foreign company cannot get this license by technical problems. So basically, that is the main aspects about setting up business or legal presence in Ukraine. Upon incorporation of the company, you will need to open a bank account. And what I would like to say that although the banking system is fully operating and new business is able to open a bank account freely, in general, current restrictions and limitations shall be taken into account. And I propose my colleague Victoria to shed some light and on the matter related to the banking system and tell us in detail about taxation and what is proposed for taxation for business under martial law. Victoria, the floor is yours.
Thank you very much, Alexander. Dear colleagues, I'm happy to welcome all of you at our today's event. And I would like to provide you with some comments regarding banking and taxation system and conditions of martial law in Ukraine. I hope this information will be useful for you and useful for your decisions regarding investment in Ukraine. So let's start with banking issues and our banking system as of today. You might have the suggestion that the banks in Ukraine do not work properly due to the war, but in fact, it's not so. The banking system is functioning and the payments are performed. The only exclusion in this context, due to the obvious reason, is the work of banks on the temporarily occupied territories and territories where the hostilities take place. Of course, as Alexander told, we cannot omit the fact that the banks operate now in Ukraine with certain peculiarities and limitations. They were introduced by the special decree of the National Bank of Ukraine for the period of martial law. You can see the requisites of this decree on our slides. And now I would like to pay attention to some of these limitations and peculiarities. Firstly, the decree establishes that the payments in cashless form shall be performed without limitations. This refers to payments within Ukraine. So this means that transfer and receipt of funds payments are allowed. If the operation is not in such a list, the bank will not process operation. I would like to highlight some examples of the situations when the payment abroad is possible, but before do not get these restrictions as a total freeze of payments from Ukraine. Major part of all commercial transactions. So when the payment abroad is possible, the first example is payment for the goods and services, the list of which is defined by the government of Ukraine. This list is very, very extensive and in fact covers all sorts of the goods and most of the services from various fields of economy: food industry, IT, textile, chemical industry, pharmaceutical industry, and many, many others. Also, the cross-border payments can be made if the resident of Ukraine cannot perform its contractual obligations under the contract on sale and purchase of goods concluded with the non-resident and returns to this non-resident the advance payment if it was received during the martial law. Another example is that the cross-border payments are allowed for repayment of interests to non-residents under the loan agreements. However, there are some requirements to the due date, sums of interests, and other conditions to be met. Another interesting and important example is that the cross-border payment is possible based on a special license of the National Bank of Ukraine issued under the order of the Cabinet of Ministers of Ukraine. It's a kind of the individual license, and the resident of Ukraine has to fulfill some requirements in order to obtain such a license and be able to transfer funds abroad. Thirdly, there are some limitations referred to the cash withdrawal. As of today, the banks can provide the client in Ukraine with the daily sum of cash in hryvnia in the amount which does not exceed 100,000 hryvnias. However, there are certain exclusions from this rule. For example, if the company needs cash to pay salaries to its employees. Another example is for withdrawal of cash in foreign currency in Ukraine. The banks can provide the client with the daily sum of cash in a foreign currency from the client's foreign currency bank account in the sum which does not exceed the equivalent of 100,000 hryvnias. Of course, separately, I would like to mention that there are also limitations for transactions related to the Russian Federation and Belarus. Also, there are some other specific restrictions, but in general, summarizing all this said, the currently effective specificities in the work of banks, they are not so critical, and the business adapted to all these challenges and deals with them each day. What is more, the legislation in Ukraine in conditions of martial law frequently changes, very frequently. So we cannot exclude that some of all these restrictions may be further lifted to a certain extent. This is the main points which I wanted to say about banks and banking system. And our next issue is taxation. I would like to thank you for changing the slide. Speaking about tax issues, from the very beginning of the war, the state was trying to support business and boost the economic activities even in such a challenging time. The sphere of taxation, it's not the exclusion. Ukraine adopted several tax laws aimed at relief of tax burden and tax control measures for business entities due to the martial law. I would like today highlight some important changes in taxation which are quite beneficial for business in connection with martial law. The first issue is management of tax revenues. Firstly, the laws of Ukraine prohibited the major part of tax audits. No scheduled tax audits can be carried out while the martial law lasts. Also, almost no unscheduled tax audits can be carried out. The unscheduled tax audits are possible in a few situations only. Still, desk and factual audits are allowed. I would like to note that such a situation is actual as of today, but of course, we cannot predict what will be further. There are some legislative initiatives aimed at renewal of some tax audits, or maybe even all of them. But as of today, there are only legislative initiatives, and they didn't pass any obligatory procedures to become the law, and these issues are still under consideration. The second issue I would like to highlight is the exemption from liability for delay in performance of certain taxpayers' obligations. In particular, if meeting the deadlines for payment taxes or filing a tax declaration is impossible for a taxpayer while martial law lasts, the taxpayer will be released from liability for the delay if performs the respective obligation within 6 months after the termination of martial law. As a general approach, this impossibility shall be connected with the properly documented force majeure or other circumstances directly related to martial law. Also, this impossibility of performance of tax obligations shall be confirmed under the special procedure with the tax office. In addition, I would like to note that if the possibility of performance of tax obligations is renewed for the taxpayer, this taxpayer will be released from liability for delays in their performance, provided that the respective tax obligations are performed within 60 calendar days from the month following the month in which the possibility is renewed. The second issue, I would like to ask my colleagues to change the slide, please. Thank you. The second issue is a new tax regime. The legislation provided for the possibility to apply the simplified taxation system with taxation of revenue at the rate of 2%. This is quite beneficial tax rate. The reporting period for this special tax regime is 1 month. And what is a great option is that this new regime is available for almost all Ukrainian companies and individual entrepreneurs. They may choose it by submitting their respective application to the tax authority. While applying such a tax regime, the business entity is released from payment of VAT. The operations of such business entity are not object of VAT taxation. But upon termination of martial law, the business entity will lose the right to use this regime. Of course, the business entity has a right to terminate it voluntarily and become the taxpayer on the general basis, the taxpayer on other rules under the laws of Ukraine. This tax regime is aimed to support business during the martial law, but still today we have some legislative initiatives which are going to terminate this regime. But again, these legislative initiatives are only under consideration. Nothing was adopted yet, and we will have a look how the situation with this tax regime will be developing. Please, next slide. Thank you. Also, as the third issue, I would like to highlight some beneficial issues regarding payment the particular taxes. Firstly, a few points about VAT. The laws of Ukraine provided for several tax reliefs. This means that several transactions are not VAT taxable. For instance, No accrual of VAT for the value of goods which are bought with VAT but further destroyed in the result of force majeure within the period of martial law. No VAT for import and supplies in the territory of Ukraine of certain personal protective equipment, medicines, medical devices. Also, no VAT for import of natural gas, which is imported by the subject of the natural gas market. No VAT for import of unscrewed aerial vehicles, binoculars, monoculars, and some other special equipment. Also, there are some tax reliefs for non-profit organizations and charitable organizations if they import certain goods to Ukraine for further free of charge transfer to the armed forces of Ukraine or other military formations. These transactions are also released from VAT. Also, I would like to know that Ukraine kept the possibility of VAT refund from the state budget to business entities. I would like to clarify that this is an opportunity for business to receive back funds paid as VAT from the budget if certain legal requirements are met. Firstly, when the martial law was imposed, legislative changes factually blocked these procedures, but further in July of the previous year, this possibility was unblocked and the companies can get the reimbursement from budget or VAT paid, of course, if the requirements are met by these companies. Another example, some exemptions regarding the excise duty. The import of certain goods to Ukraine by public associations or charitable organizations, they can be exempt from the excise tax if such goods are transferred for free of charge to the armed forces of Ukraine and other military formations. As we see, the major part of these tax reliefs, tax benefits are related to martial law and aimed at protection of the country. But at the same time, even before the war, Ukraine had several tax regimes which are beneficial for the specific fields of economy. And even before the war and now, they are still actual and they are functioning. So, in fact, even in conditions of martial law, the tax system of Ukraine may provide for beneficial taxation. Of course, these highlights which I made, they are not all. There are a lot of tax reliefs related to some specific taxes, for instance, real estate tax, land tax, and many others. So when planning your activities here in Ukraine, it's a good idea to check whether any activities fall under some tax reliefs here in Ukraine and which taxation will be entailed by the activities. Thank you for your attention. And I would like to give the word to my colleague Pavlo Loginov. Please tell us a little bit about competition, about the issues related to the functioning of Anti-Monopoly Committee of Ukraine. Pavlo, please.
Thank you, Victoria. Thank you for the introduction. Good day to all the dear colleagues who are now with us. My name is Pavlo Loginov. I am head of competition practice in GOLAW, and I would like to remind you a bit about competition compliance, which was a big thing pre-war. Important that now Anti-Monopoly Committee of Ukraine is fully operational. It continues to maintain almost all its functions, despite the several months of pause at the beginning of the war. So in order to be in compliance with competition law in Ukraine, you should be careful about, first of all, merger control, which I will stop a little bit later in detail, and about compliance with competition legislation, because now Anti-Monopoly Committee resumes all pending cases and started several cases, important markets such as telecom, and oil and gas sectors in Ukraine. And it could start even more because it is eager for new cases. Also, the Committee of Ukraine is responsible for unfair competition. And this issue also should be considered. It is specific for Ukraine, that is consider all cases related to, for example, advertising materials and so on. And also Anti-Monopoly Committee of the state body of control for public procurement. Any appeals to procurement process should be done to Anti-Monopoly Committee as well. And I will stop in more details for merger control. Please, next slide. What is important about merger control is that practically any transaction foreign to foreign which with parties exposure to the Ukrainian market could be caught by merger control rules. Basically, if some of the party had sales for euro for millions, this case could be considered by Anti-Monopoly Committee and requires prior approval. The Anti-Monopoly Committee now is considering a lot of these cases as it was pre-war, and so I advise that any transaction with shares or any control related operations abroad should be considered for compliance with Ukrainian legislation, as it can be caught or will be caught in the future by Anti-Monopoly Committee of Ukraine. That's basically all which I would remind you about competition in Ukraine, and I would like to transfer the word to my colleague Katerina, who will stop more on labor issues in Ukraine now. Thank you. Katerina, the floor is yours.
Thank you, Pavlo. My name is Katerina Tsvetkova. I am an attorney at law and counsel at GOLAW. Labor law is one of my focus areas, and I chair the labor and employment practice of GOLAW. Today, I am going to briefly outline key features of labor relationship in Ukraine during martial law. We will take a look at special rules that are applicable only during martial law. And also we will discuss mobilization and military service in the context of labor relations. So martial law significantly affected labor and employment relationship. When the war started, millions of employees moved to more safe western regions of Ukraine or have gone abroad. Many employees started working remotely. Some companies have relocated their production facilities to areas where there are no active hostilities. And of course, as we know, many Ukrainian men are called up for military service and now are defending our country from Russian aggression. Therefore, business in Ukraine continues to operate, but under challenging external circumstances. During martial law, regulation on labor issues have been changed significantly. You should know that the basis of Ukrainian labor legislation is the labor code that was adopted in 1971 during Soviet times. And of course, it was changed many times in order to be adjusted to modern reality. But when the full-scale war started, it turned out that Ukrainian legislation is not adapted to wartime. Therefore, in March 2022, the Ukrainian parliament adopted a new law on arrangement of labor relations during martial law. The rules established by the new law are applicable only during wartime and only during martial law. It is important that the law provides for more opportunities for employers during martial law, and it is really beneficial if you are planning to conduct any business activity in Ukraine right now. So let's take a look at key features of labor relationship in Ukraine provided by the new law that you can see on your slide. First one, the previous slide, please. Thank you. So the first one, a written labor agreement is not obligatory now. During martial law, the form of the labor agreement is determined by agreement of the parties, the employer and the employee. It means that the parties of labor relations are not obliged to enter into written labor agreement in cases as required in a peacetime, for example, when hiring minors. Now, in order to hire an employee, it is enough for an employer to issue an appropriate order and to notify a tax service. It is important that such simplified procedure should take place with the consent of the employee. The second one is probation period. In peace time, it is forbidden to establish probation period for certain categories of employees. For example, for pregnant women, for single mothers, for minors, and so on. But during martial law, the probation period may be established for any category of employees without any restrictions provided by the labor code. Probation period in Ukraine can be established for maximum 3 months. The third rule is about fixed-term labor agreement. As I already said, as a result of hostilities, lots of employees have evacuated to different places or gone abroad. Now employers have possibility to enter into fixed-term labor agreements with new employees for the period of martial law or for the period of replacement of a temporarily absent employee. In this case, labor relations with absent employees are not terminated, but for the period of their temporary absence, an employer can enter into a fixed-term labor agreement with another employee. And of course, it is very convenient for employers. The next rule is about change of essential terms of employment. Essential terms of employment are, for example, the system and amount of salary, benefits, working hours, establishment of part-time work, and so on. The procedure of changing essential terms of employment has also been simplified. An employer may change essential terms of employment without giving an employee 2 months' notice, as it is required in a peaceful time. The law clarifies that during martial law, an employer should notify an employee about any changes no later than the changes are introduced. It means that, for example, today, an employer has right to notify an employee about new working conditions, and tomorrow such new working conditions can be already implemented. The next point is about remuneration payments. The martial law itself doesn't cause any decrease in the amount of salary. It means that if an employee works, he must be paid a salary in accordance with the terms of his employment agreement. But if wages cannot be paid on time to an employee during two ongoing military actions due to hostilities, the payment of such wages can be suspended. The law specifies that the employer shall be exempt from any liability for violating the terms of wages payment, provided if there are any evidence that this violation was caused by military actions, by any force majeure. But at the same time, the law obliges an employer to pay salaries to employees as soon as the company resumes its business activity. The next thing is working time. In a peaceful time, working hours in Ukraine cannot exceed 40 hours per week. But for the period of wartime, this number is increased to 60 hours per week, but only for employees who are engaged in work on critical infrastructure. And as you may already know, during the war, Ukrainian employees have no holidays. It means that official holidays, day offs, and also this shortened working time on a day preceding a holiday are not applicable during wartime. Thus, all holidays are considered just as ordinary working days, and they are paid for respectively. And the next rule is about leave. During the war, Ukrainian employees have right to go on annual paid leave for 24 calendar days or other leave, any other kind of leave. In its turn, an employer may refuse to grant an employee leave if such employee works at critical infrastructure. However, in any case, an employer has no right to refuse maternity leave and also child care leave. In addition, an employee can take unpaid leave for the entire period of martial law. And also, please take a note that such leave is granted only at the request of employee, and an employer has no right to send employee on unpaid leave, but by his own initiative or by force. It is important to mention that all these rules that you see on the screen can be applied only during martial law, and please note that application of these rules remains at the discretion of an employer. For example, if an employer has right not to apply any of mentioned rules and consider, for example, holidays as holidays, not as working days according to the new law. Next slide, please. The other interesting point is suspension of employment. So the new law provides for completely new concept. During the war, it is possible to suspend the labor agreement. The law clarifies that suspension of the employment agreement is possible in connection with military aggression against Ukraine, which excludes the possibility, from one hand, of an employer to provide an employee with work, and from the other hand, of an employee to perform his working duties established by his labor agreement. For example, if offices, premises of the employer are located at the temporarily occupied territory, and therefore an employer cannot provide employee with work, and at the same time, employees have no access to offices, to premises, or they have evacuated to more safe places, and also they have no possibility to perform their working duties. It can be ground for suspension. Accordingly, an employer is not obliged in case of suspension to accrue and to pay salary for the whole period of suspension of the employment. The suspension can be carried out for a term no longer than the period of martial law. However, suspension does not result in termination of employer-employee relations. Such relations are just suspended. And also a suspension should be formalized by the employee's order. Under the law, the aggressor state, Russia, shall be responsible for compensating employees for salaries and other guaranteed payments due to an employee during the period when the agreement is suspended. However, the procedure for such compensation has not been provided yet. Now let's talk about dismissal during the wartime. Next slide, please. So the termination of employment during the war is possible on general grounds prescribed by Labor Code of Ukraine. As before, an employee may be dismissed on his own initiative with the consent of the parties or on the initiative of an employer, for example, due to staff reduction, non-performance, and so on. But there are some special rules of dismissal during wartime. For example, an employee may terminate the employment on his own initiative without the standard 2 weeks prior notice if the territory where the company employer is located is under hostilities and the employee's life and health are in danger. However, this rule does not apply to employees engaged in social benefit activities or a critical infrastructure locations. Also, during martial law, it is not required to ask for the consent of the trade union to dismiss an employee on the grounds of staff reduction, systematic non-performance of employment obligations, and so on. And also, new grounds for dismissal are introduced. The law provides for such grounds for dismissal, as you can see, for example, absence of an employee at work and information about the reasons for such absence for more than 4 consecutive months. Also, we have one new ground for dismissal, such as an impossibility of an employer to provide an employee with work specified in the employment agreement due to the destruction of production, organizational and technical conditions, means of production or property of the employer as a result of hostilities. So, as we can see, new grounds for dismissal are connected with military aggression against Ukraine. And our last topic is mobilization and military service. Next slide, please. As I previously mentioned, now many Ukrainian men are called up for military service and now are defending our country from Russian enemy. You should know that employers are not obliged to pay an average salary to employees called up for military service, but such employees shall remain employed and continue to hold their positions. Previously, before July 2022, employers had to continue paying such employees average salaries for the entire period of the employees' military service. But as of today, employers are obliged to maintain only working places and positions of employees called up for military service. And also we have a special procedure in Ukraine. It is called reservation of employees. Reservation of employees is a special procedure that allows employees to be exempted from calling up for military service during martial law and to continue working for their employers. In the private sector, in business sector, employees of the following companies can be exempted from mobilization. First, it's companies instructed to perform mobilization tasks. Also, companies producing goods, performing work, or rendering services required for the needs of the armed forces of Ukraine, and also companies that are critically important for the functioning of the economy of Ukraine during martial law. As a general rule, the number of employees subject to reservation must not exceed 50% of the company's employees liable for military service. So I have briefly outlined key features of labor relation during martial law in Ukraine. And so as we can see, during wartime, employers' rights are really extended. And of course, that is really beneficial for foreign investors who decide to start operating in Ukraine right now. Our team supports clients during this difficult time and advises them on new rules of labor relations, remote work mode, relocation of their business, military service, and mobilization. I hope that this information was convenient for you, and thank you for your attention.
Thank you, Katerina. Thank you, colleagues. Okay, just one moment. We have questions here. So Ralph asked purchase of real estate under martial law for a foreigner, legal requirements and risks. So first of all, I would like to mention that the law does not limit somehow foreigners from purchasing real estate in Ukraine unless you're from Russia. So if you're not from Russia, you are free to purchase real estate, and you can it can be done directly by individual, or you can purchase real estate to your foreign company or established company here in Ukraine and purchase real estate. Of course, there are some limitations, but they were in force also before the war. It relates to agricultural land. It cannot be purchased by foreigners. In other cases, you are free to choose and purchase whenever you want. As to legal requirements and risks, real estate shall be purchased by concluding the notarial deal. So the deal will be certified by a notary, and depending on the type of assets, in some cases it's suitable to purchase for a company, for example, if it is a commercial asset or so on. Also, in certain cases, if the subject is integrity complex, for example, you will have to do the merger control, which was mentioned by Pavlo. So nothing crucial. About risks, of course, general risks, as in any other country, are associated with the previous owner, with the right of ownership. So it is recommended to check all this before the deal, to check are there any encumbrances or other risks associated with previous owners. And usually we support such cases in two stages. First is due diligence, and after this we support the deal itself. Okay, so if no other questions from our participants, please, you can see all our channels and social media, you can subscribe, because much more interesting information about the legal matters and concerns of doing business in Ukraine. We share these thoughts in this social media. So if you subscribe, you will tuned and you will know the latest legislative developments and news. So choose whenever you are more convenient to use, whether it's Telegram or Facebook. All these social media have the same, basically the same content. And here's our contacts. If you have any further questions about doing business in Ukraine, taxation, employment, mergers control, please feel free to approach any of us. You can see the contacts here on the slide. Let's keep in touch and stay safe. And the last slide, you just do not need to write anything, just can scan this QR code and be happy with subscription to our social media. Okay. Thank you very much. Have a nice day. Goodbye. The presentation will be sent to each of you, and you will have the access to recording of this webinar on our YouTube channel.
Thank you. Goodbye.
Thank you for your attention.
Thank you. Bye.
Goodbye.